Welcome back everybody. In this last chapter, we'll look at how the Anglo-Saxon legal system evolved into what is known both colloquially and officially as English common law, the main ancestor of the contemporary British legal system and of all common law. Now, in part 3, we ended by noting that the Anglo-Saxon legal system provided the emergent English nation-state with a system of government necessary for its self-determination. In the wake of the collapse of the Roman Empire, where former provinces would have had to be self-sufficient, such a system of governance would prove indispensable, which is why, incredibly, this government has survived right up until today. But as regards common law, there is one rather glaring problem. Anglo-Saxon law wasn't very common. We have a plethora of key ingredients of what will become common law, such as a legal system that applies to everybody within its jurisdiction, and that this law is a vehicle of justice and social stability, and that it's based upon rudimentary empirical induction. But the law lacked the truly common touch, and was yet to reach its zenith as institutionally regular and regulated from the centre. Although the Old English monarchy would issue the kind of charters we saw in part 3 to cover the entire realm, there were rather few and far between, and covered very little of actual law. Most law and legal proceedings were left to the shire and 100 courts to deal with, and as a result, most law and jurisdiction was quite local, rather than national. Certainly the legal culture was very similar, but the particulars between jurisdictions varied. Thus, even after the unification of the Anglo-Saxon kingdoms and Norse colonies into England, law, though still guaranteed centrally by the monarch, was mostly arbitrated locally, using local customs. The idea of one single body of law did not exist. The local districts were ancient, with their jurisdictions more or less resembling the former kingdoms and shires that existed prior to the unification of the English. These districts still live on today in very much the same forms. In fact, it may be that England was for some time divided into the three laws, which in the context of the new English state were the three jurisdictions. These three jurisdictions were carried over from the old divides of the West Saxon, Mercian and Danish kingdoms, though the exact extent to which this distinction mattered in the life of the English state is unclear. It speaks much, though, to the English character that the area of land formerly controlled by the Vikings was known as the Danelaw. Legality and jurisdiction were essential to the English vision of the world. What we do know is that the Anglo-Saxon English state became very sophisticated and wealthy. It is not a coincidence that it attracted so much attention in 1066 from ambitious claimants to the throne. The Domesday Book has long been recognised as testament to this sophistication. To the English, land was a legal matter, the origin of the concept of private and communal property, and the country was ordered with a legal exactitude unrivalled. The Domesday survey of the entire country was only possible with the legally defined and ordered boundaries, jurisdictions, and network of administrative infrastructure that England had developed. It's all the more impressive that this was conducted even in the recently conquered England, the north of which had just been subjected to something which the Domesday Book concisely refers to as wasteland. But ironically, it was the conquering Normans, with their brutal, domineering style of politics, whose ambition would in time make them see in England an opportunity for a more powerful, stable and united political and legal system, a legal and constitutional system that would cement monarch and people, and create an alternative model of government to either the base tribal system or the cosmopolitan corporatist system that have otherwise been so ubiquitous. It was an opportunity to create something tougher than either the Normanno-Roman or Anglo-Saxon legal systems which, though they could not have known it, would allow the country to weather the storm of a very turbulent Europe, and indeed go on to spread all of those Anglo-Saxon and coming English notions of politics, economics and law around the world. This was a process that culminated with Henry II. But the period between 1066 and his reign was very far from straightforward. We won't go into all of the details in this essay, but there are some important points to know that put Henry II's actions into context. Firstly, remember that William I did not in fact come to England as a conqueror. He came on the basis that he was the legitimate heir to the throne and would dethrone the usurper, Harold Godwinson. Thus, there was never an intention to stamp out England as a concept. This was not meant to be a takeover or subjugation or even extermination. As such, successive Norman monarchs and their ancestors would reaffirm their commitment to be king of the English and to rule them in line with their ancient customs. This provided a link of heritage that will continue to form a buffer against feudalism and Europeanisation. Crucially, Henry I established his kingship as a populist one in the wake of the abusive, raucous rule of his brother Prior. Thus, the possibility of England, or Englishness, being lost in the turmoil of the Norman takeover and subsequent guerrilla fighting was quickly overcome. And Henry was important for many other reasons. He married the daughter of the King of Scotland, who carried the Anglo-Saxon bloodline, thus bringing together the Anglo-Norman as well as making ties with the Scottish kingdom. He set about preventing the debasing of the coinage, which was important because the English coinage had long been strong. And we see a number of important legal and constitutional developments. It is from Henry I's reign that we get the Textus Recensis, which sought to preserve the traditional codes of the English, and we get the famous Legis Henrici Primi, which was an attempt at a legal treatise. It is a jumbled document highlighting old English laws and filling gaps with foreign legal sources such as the Lex Salica, the laws of the Franks. But it shows an attempt by a professional jurist to maintain English customs even if handled by alien hands. The text is also an important source for those studying the transition between pure Anglo-Saxon law and the Notes of Doomsday, and the coming development of Henry II and the later Treatise of Glanville. Importantly for us, we also get a number of developments that we can retrospectively identify as proto-common. Henry I's policies began to centralise the country. This was mainly done in the administrative sector, such as via finances and the King's Council, the meat and potatoes of rule. But it also included very important legal developments. Royal justice would step in, as a good Anglo-Saxon monarchy would have, where local justice was wanting, but he also issued royal writs, or orders, to settlements, and he began installing loyal court members as sheriffs to do work that would have been the sole preserve of the local barons in the feudal system. There was one more important development. Henry had ordered that the Anglo-Saxon shire and 100 courts should continue and even be held in the same ancient places as in the past. But he also created the justice in eyre and eyre courts. These were travelling royal justices and the highest in the land. They were irregular, but it was an important sign that the country was technically united and under one ultimate law, the royal law, the law of central government. And crucially, even in the eyre courts, the local people were still consulted. The path to the modern jury was not snuffed out. Finally, for our context, there is the rather large issue of the devastating civil war that overtook England after the reign of Henry I. The circumstances of the war are not important for us, save for the fact that it was fought between two claimants. One, the daughter of Henry I, Matilda, and two, his nephew Stephen. The constitutional clarity of these two claimants between a woman and a nephew blurred the matter, an issue further muddied because Henry I had designated Matilda his heir, but Stephen, though not widely lauded in history, was a gregarious leader and by all accounts brave and rather merciful, even to the point of his own detriment. Quite the chivalric model. The Civil War has been called the Anarchy, which tells you quite a lot about it. It saw an extensive breakdown in law and society. It gave the English a taste of full feudal life, with local barons and thugs enacting martial rule over their immediate districts, competing with each other entirely recklessly and without any concern or rights upheld for the people. Consider how the breakdown of politics during the Brexit procedure showed the public how corrupt and awful the would-be oligarchs of corporates and MPs are if they hold sway. And now multiply that 1,000 times and you will have an understanding of how the anarchy left people begging for a return to a nation with stability and unity. That meant political centralisation. Thus, much as the Brexit process led to Boris receiving the benefit of the doubt and a big majority, which in democratic terms is the same as strong central government, so too the Civil War meant that there weren't just all of the ingredients necessary for common law by the time of Henry II, there was also now the political will and social opportunity to create it. So it was after this tumult that Henry II was able to refashion Englishness into a new solidifying form, the beginnings of the England that we know today. Upon coming to the throne, something that had been agreed with Stephen, Henry II began his mission to restore the monarchy to its emergent glory under his namesake. Everybody had high hopes. The Prior of Westminster, where Henry and Stephen ratified their agreement, reportedly told Henry that he was the new light, a leader given to us by God, who shall found a new Jerusalem. The Anglo-Saxon Chronicle is equally steep in its praise for Henry. When Stephen finally died, Henry was kept away from England and his coronation for some 6 weeks, but in that time there was no sense of further upheaval. By all accounts and his own reign, Henry was one of those few people in history, the right man at the right time. There was a general feeling of returning to the good old days, to the laws of Edward the Confessor, as was said by Henry's Norman forebears. Yet much had now happened between 1066 and Henry's reign, and a new mixed culture of Normanno-English was arising, with people who had simply not been around during the Anglo-Saxon era. There was a confusing mix of competing and overlapping traditional, feudal, ecclesiastical, and arbitrary law, which both opened up the possibility to legal developments, whilst nudging people towards a desire for a law that was again straightforward and, shall we say, common. The result was that Henry had more flexibility to build upon the past, rather than simply trying or claiming to uphold it. The first things that Henry did were to reaffirm and revive the practices of his grandfather. He immediately secured the treasury and appointed suitable, talented men to the great offices of state, regardless of their former allegiance. He also stamped out any lingering notions of baronial autonomy and feudal caprice. It was essential to pacify the kingdom and its rogue lords and local magnates. The Treaty of Winchester, agreed with Stephen, stated that any unlicensed Civil War-era castles were to be torn down. Remember that the purpose of a Norman castle was less defence and more tyranny. It was a fortress from which to control the surrounding area. During the Civil War, various barons had erected their own castles to dominate their would-be fiefdoms. Tearing them down did much for Henry. He appeared liberator to his people. He removed the potential for future baronial resistance, and he was declaring that he alone was in charge and the purveyor of authority, a message with the common and aristocratic audiences both in mind. Henry also moved to restore his power abroad and to protect his borders. Scotland had taken advantage of the anarchy and had conquered areas of the north of England. Henry had the Scottish king, Malcolm IV, who fortunately for Henry was a mere boy at this point, relinquish those territories and pay homage, before the two of them set out to do the same to Wales, which had also taken advantage of England's former woes. All the while, it seems that Henry was appealing to English history as well. His defeat of the renegade baron, Hugh de Mortimer, took place at Brignorth, the same place Henry I had quelled a similar antagonist, and Henry met the Scottish king Malcolm at Chester, the same place where the Anglo-Saxon king Edgar had the mini-kings of Britain pay homage to him. Over time, Henry managed to amass large swathes of land in France to himself too, and the compounding effect of this was profound. For one, all of this campaigning meant that Henry was visible to the people, and it was evident that he took personal care and pride in the kingdom. Furthermore, Henry had put England back on the map. It was now a mini-empire and once again stable within. So what Henry accomplishes is to bring the functioning royal power that had been stamped on the centre of governance to the rest of the country, to the provinces. This was an enormous achievement in a world where most states were barely held together feudal confederacies. Once these fundamentals of royal power, like money, military and homage, had been re-established, Henry began the constitutional developments that brought about common law proper. One major step was the creation of the Constitutions of Clarendon. These sought to greatly reduce the autonomy of the Church. Remember that the Church operated a separate and competing legal system within Europe, and thus in England it was in the way of Henry's vision of a royal supremacy. This was no small undertaking. Aside from taking on the might of the European Church, the Church in England owned as much as a fifth of its land, and a sixth of the population were churchmen of one kind or another. Henry's battle against the Church was mixed, to say the least. It was the source of the dispute between Henry and his one-time Uber minister Thomas Becket, who had been made joint chancellor and archbishop. This was a consolidation of power that proved that centralisation done badly could go wrong. Certainly Henry would come to regret it, as the conflict ended with Becket's death and Henry's penance. But after William I made the English Church fully separate, it was Henry II's attempt to reimpose a subsumed church that would one day end with Henry VIII's act of royal supremacy and the sovereignty of Parliament. Much more successful was Henry's overhaul of the secular government, however. The writs began again. They were developed to resolve the most common legal problems, and one of the benefits of the developing common law was that it was standardised and much more predictable and efficient. Writs allow royal justice to be done on behalf of the monarch without their literal presence. Delegation and trust have always been integral to good leadership, and Henry was one of history's great delegators. Indeed, delegation was one of the great achievements of the Anglo-Norman synthesis, and central to its peculiar development. A nation-state like England could operate via delegation because they had a single identity, a single mission, a single organisation. This was not possible under either a highly divided feudal or corporate system, nor under an absolute system. It is well known that one of the problems with Nazi Germany's military was that it had overlapping authorities, because Hitler was afraid to effectively delegate command to any one person. But Henry could afford it, usually, because of his own powerful reputation and attention to detail. He didn't delegate because the detail bored him, but because it was good governance, and Henry had much to govern. Henry extended his attention to that other great embodiment of royal justice, the sheriff. Much as with the lords, some sheriffs had grown accustomed to abusing their power during the Civil War. This also showed how centralised power could turn into a sprawling, corrupt bureaucracy if run oligarchically, as its members had got used to. Henry rectified this. He showed how centralised power could be a vehicle against corruption and for stability if run constitutionally. The inquest of sheriffs in 1170 resulted in Henry removing most sheriffs and replacing them with men from the exchequer, men with no local loyalties or pretensions of autonomy. In a moment, Henry reversed another slide into feudalism that had been occurring. Sheriffs would not drift from royal appointments to local grandees, as had happened in France or Germany, and de facto during the anarchy. The sheriff was to become a lesser figure in Henry's system, and a new figure emerged in full, the justice in heir. Like any good government, Henry operated on precedent. As said earlier, Henry I began the process of justices in heir, judges who would travel the country to conduct royal business. Henry II took this idea and created a brand new legal system based upon it via the famous Assize of Clarendon in 1166. Itinerant or travelling justices would roam the shires inquiring into the old juries of presentment from each 100. They would name local suspects, and the sheriff would locate, arrest and bring to court those named. Where they went, these arms of the monarchs took over from the local leaders. Lords were forbidden to exclude either the sheriff or royal justice from local government. In a moment, jurisdiction had been centralised in one place and made common across the land. In one place we have the origins of common law, the police, and the integration of all authorities for the processing of justice. Henry had spent a long time getting this right. The 12 years between coming to the throne and the issuing of the Assize of Clarendon no doubt involved the testing of the itinerant judges and drumming up of support. And the efforts showed. There was an immediate improvement in the efficiency of justice. On just the first run after the Assize, Yorkshire showed that 127 felons had failed or fled their trial by ordeal. Compare this to Hampshire, which had not been visited by the royal justices in heir, where a mere 4 felons in total were brought to justice, and in Shropshire the grand total was 0. The system was rough around the edges, to say the least. If the accused fled, they became outlaws and justice was considered done in proxy. If they didn't, they were subjected to the ordeal via water rather than hot irons officially, and that was a bit of a coin toss itself. But it was a start, and as we saw in part 3, pretty much the best that could be done in a world where testimony was the only real form of evidence, short of catching somebody red-handed. Justice also paid. Those who were found guilty forfeited their chattel to the state, which in this time meant to the king. For example, in Lincoln alone, 105 cases saw total fines amounting to £250, enough to pay 20 knights or 165 foot soldiers for a year. Already then, we see that taxation and the martial foundation of the medieval monarchy were heavily tied, and that is something that will become central to all of English history. Again and again, later parliaments and monarchs will argue over taxation and the raising of military forces. For now though, Henry was supreme. The success of the system meant that in 1175, Henry made the itinerant justices systematic and national. They embarked upon what were called general heirs, routine circuits which royal justices would embark upon. The judges would arrive at a local court, hear cases as per their jurisdiction, and move on. Moreover, the general heir was not just a legal process. Royal justices were the eyes and ears of the monarch, dealing with all matters of governance, along with the sheriff and other members of proto-civil service. The result of this was profound and compounding. Each heir was basically able to provide a mini Domesday, a general account of the country, the level of crime, the level of corruption, the level of taxes, how well local leaders were performing and the issues currently prevailing in any shire or hundred. Such information allowed the monarchy to very effectively and easily manage the country without having to overgeneralise. It was modern governmental planning, medieval style. Moreover, there was another development central to the creation of common law and the English legal system. Applying a common legal system with systematic matters of jurisdiction resulted in the creation and development of a common law, since the judges would hear the same kind of cases upon the same basis again and again. And coupled with the routine influx of information that each heir brought in, there began to emerge a scholarly and professional body of justices and lawyers who were taking increasing interest in what was becoming the discipline of law. This development was welcomed. Henry's genius was thus to combine the best of governments and law that had come before him, and in this regard he aped that most famous of his forebears, Alfred the Great, who had done the same during his reign. Alfred was famously a scholarly king, and Henry's endeavours required a certain intellectualism. As in all things, Henry was hot on the detail, but also wise enough to delegate. The result was the beginning of a scholarly, professional legal class, where before the law had been a vocational matter at best. The changes Henry wanted and brought about required a full-time, competent body of justices, who both knew the law and could develop it suitably well. The very process of building common law required the emergence of such people. Law was now something that could be learnt for the whole country, something that you could think about. That mass of incoming information, not the result of scripture or opinion, was real evidence that real scholarship could be done with. The would-be legal profession had real cases to ponder, recurrent dilemmas to consider, and solutions to test and discuss with each other. Such scholarship would, for example, allow the monarchy to design more effective and efficient standardised writs. It is from this period that we also get the famous Glanville Treatise of English law, a tremendous update and improvement on the Henricus Primi we saw earlier, showing the clarity of law coming through, as well as the issues being considered. Furthermore, the origins of our modern legal training, with the various schools as well as the central court known as the bench, are found here as well. And finally, we have one more crucial development springing from this moment: the modern jury. We've already seen that Anglo-Saxon England operated a system of deep engagement with the system of compurgation and oath-taking central to legal proceedings, and juries of presentment, grand juries, evolved during the Norman period, and as we've seen, were called upon by itinerant justices to name suspects. The number of people required for a jury was 12, the same as required today. The Assize of Clarendon created a slimmed-down, efficient justice system. It removed the compurgation form of trial, and justice became an efficient matter of accusation by the grand jury, trial by ordeal, and thus judgment. Clearly this jury isn't what most of us think of as juries today. This jury, the grand jury, simply named potential guilty parties. We today still refer to this kind of jury as the grand jury, but it certainly isn't what we mean when we say trial by jury. Since trials were conducted by ordeal, one way or the other, you'd have to go through a punishing process or simply flee. It was, however, a short-lived transition, because from this grand jury of presentment came the contemporary notion of a select 12 free men who would pass judgment themselves as a judge passes sentence. In 1215, at the Fourth Lateran Council, the Church forbade the involvement of clerics in the ordeal, which rendered the ordeal rather moot, since it was all based upon God. England therefore needed to replace the ordeal with another method of determining guilt. Henry II's descendant, Henry III, set his justices to the task. In Europe, the result of the abolition of the ordeal was that horrific development that for many epitomises the medieval era, torture. Not that torture itself was new, but the process of assuming guilt and then engaging in inquisitorial torture to discern the nature of this guilt, or the truth as they called it, was a medieval systemisation of faux justice. This system was much more open to corruption, of the pernicious rather than merciful kind, than the ordeal, because there was little chance involved. If the authorities wanted you to be found guilty, sufficient suffering could be brought to bear to make it so. This process of arrest, torture and confession was thankfully unnecessary in England with its long heritage of law. Most recently, the Justices of England had spent some decades now asking the grand jury for testimony as to why it is accusing any person, and they had spent those same decades developing practices. It was thus a simple decision. The last trial by ordeal in England was in 1219. The first criminal trial by jury was in 1220. Jurors had previously taken oaths to give truthful answers, or veredictum in Latin, a verdict. Now they were asked to give one more verdict, guilty or not guilty. Thus was born the modern trial by jury. The grand jury would bring accusations to court, and a second, so-called petty jury, would determine guilt. Henry II's reforms were an important step between trial by jury and the compurgation system, laying the intellectual and practical groundwork for it. There was still a long way to go, and much to develop from Henry II's time. But what we can see from his reign onwards is an increasingly routine application and enforcement of one single secular law stemming from one single body, the monarchy and its royal courts. Hence why this is also the ancestor of our modern parliament having ultimate jurisdiction over all the laws of the land. Henry had managed to make himself an emperor in all but name, but it was an imperium that was based on highly effective systems and ancient traditions of justice, participation, nationhood and empirical induction. Thus began the story of England, a tussle for this centralised power, and those who wished to uphold those values and those who wished to abuse them. England didn't have long to wait for the first test. The lure of power was too much for King John. Unlike Henry, he was neither inspiring nor trusting, and he used his power to enrich himself whilst belittling the nation. The result of this was, of course, Magna Carta. But I hope that you can now see that Magna Carta was a part of the evolution of the constitution and law. Henry's reforms had created a system of governance and law that was for everybody. It made royal legality the yardstick of all legality. It made royal justice routine, accessible and fair. And Magna Carta's greatness lay in legislating this change. It made Henry's model of governance and law constitutionally settled, despite initial attempts to roll back royal power. Magna Carta certainly brought John and his abusive government to heel, but it also cemented in England an opposition to all forms of tyranny and arbitrary power, including oligarchy like feudalism or corporatism. The battle over this balance between these two forms of government has plagued and continues to plague societies across the world, so it is the eternal achievement of Henry II and the Anglo-Normans to have brokered such an arrangement. It is the genetic heritage that inspired opposition to Charles I, and on the flip side, it is what inspired the opposition to the cosmopolitan oligarchs against Brexit. I note that with the by-election just gone, that the Labour Party is still paying for this and the Conservatives still benefiting from it. Henry's general heirs ran for over a century, until they were overcome by the sheer amount of work expected of them. Yet the experiment had brought enormous benefits to England and taught the nation much. The learning produced from this allowed England to adapt and build a better system of even greater delegation. Magna Carta was a part of this and helped rebalance the constitution. It would take another of those practical, powerful monarchs to raise from the settlement of Magna Carta a legal system up to the task. As such, it was Edward I who established the assize court system, a system that has run in some form or another up until today, with the assize courts themselves being replaced in 1972 with permanent crown courts for contemporary circuit judges to use. Yes, to this day, circuit judges are still trained and enact the Crown's justice across the country. Through all of this then, Henry fully centralises law, thus ensuring that it is national and common. He institutionalises the existing components of Anglo-Saxon and Anglo-Norman law, making the law a complete subset of government, thus producing those royal courts. As we have seen, before this law was guaranteed by the monarch, but conducted almost entirely locally, with regional jurisdictions. This now fell away. Henry nationalises the law, taking it out of the hands of private lords and local bigwigs. In practice, this stamped out the tendency of the Anglo-Norman aristocracy to try and run their local areas like feudal lords, which would have broken up England and destroyed the English as a nation. Henry II thus ensured that England remained a royal country, a country of monarchy and nation, not feudalism or republicanism. And that monarchy too continues to this day, still at the heart of a spider's web of delegated governance and law.